Good morning. See, this is most important judgment which will help you when you conduct the cases for the Pocso offenders. And even if you could not succeed before the trial court, will be far better to argue with the points discussed and ratio decidendi was given in this judgment by Supreme Court by quoting these, and you must train to conduct the case by by digging or by eliciting these points during cross examinations. This is AR 2025 Supreme Court 4717. AR 2025 Supreme Court 4717. Akhtar Ali alias Ali Akhtar alias Shahim alias Raja Ustad versus State of Uttarakhand. They were convicted by the trial court, appellate court also, High Court confirmed the sentence, but Supreme Court has on these facts, which is most important, acquitted in. Number one, motive merely on lust lacked independent and credible evidence. Last scene theory was also not established due to lack of proximity in time and place. Furthermore, scientific evidence including DNA match and mobile surveillance claims were riddled with inconsistencies and lacking its credibility. Tampering with the forensic sample and planting semen of accused on these samples were indicated by material on record. Prosecution also failed to examine crucial witness who found the body, which is further weakened the case. So, then they say another ground. Temporary driver engaged by witness who disappeared on the day next to his engagement says was not sufficient to establish the motive. Said witness failed to report disappearance of accused for 2 to 3 days, despite having participated in search of the girl. And then the last scene theory. Accused persons were seen in close proximity to the victim girl shortly before the time when she went missing. That is not sufficient. Victim girl was not seen with the accused company. When the police were claiming that accused were apprehended based upon prior secret information was completely contradicted by employer of one of the accused. So, prosecution once proves the proximity of time and place as to offense, then only question it will shift to burden to the accused. Then DNA report could not be relied due to significant investigative irregularities and scientific inconsistency. Arrest accused were highly suspicious as claimed by IO about tracing him via mobile surveillance were contradicted by statement of nodal officer that call details were obtained months after arrest. Recovery of hair bond of victim was also dubious. Related recovery memo also undated. Alleged presence of semen on cervical swab of victim but not on vaginal and smear samples. Strongly suggested tampering and planting evidence. Serious doubts were raised about qualification of prosecution witness, DNA expert, it is most important, who held a degree in botany, a subject unrelated to human DNA profiling. Entire process is unbelievable. So all these grounds, you can go through the entirety of judgment, keep it on record and take down these points and operate your defense. Best wishes.